Why don't we just tell our clients to use TODs, PODs, and beneficiary designations? You can plaster them on every asset, and of course, they avoid probate. They're cheap and they're easy. Most people accept these cheap estate planning alternatives as a way to help avoid probate. But I remind people that cheap things aren't reliable, and more importantly, they can be dangerous. I'm going to give you 5 rock solid reasons why, in almost every situation, you should avoid them. These shortcuts sound convenient, but they can cost your family tens or even hundreds of thousands of dollars, spark family fights, and even lead to the loss of your most valuable physical asset, your family home. Let's break it down. Reason number one, you abandon planning. These are not plans, they're devices. They're devices that were contrived first by third parties, such as banks and insurance companies. Legislators later adopted them to offer a cheap fix for those who wanted it for real estate and automobiles. But they don't implement a plan. No plan is as simple as saying, I want my assets to go to my kids. That's an objective. A plan is how. They answer questions, they solve problems, and they address foreseeable, even if unlikely situations. And they provide solutions. Let me give you some examples. What if a beneficiary becomes disabled, incompetent, or incapacitated? Well, in that situation, there's only one solution other than the loss of those assets because of their incompetence, disability, or incapacitated, and that's to open up a guardianship, probate. What if they have creditors ready to seize the inheritance? Well, that means the assets get lost to third parties. What if they're receiving government benefits that allow a state to seize the assets for benefits that have been paid in the past? That's Medicaid. That means the assets are lost. What if they're unable to manage their inheritance due to addiction, whether substance abuse, drugs, or alcohol, or non substance addictions like gambling? When you create a beneficiary designation, TOD or POD, you give up all control and planning. You solve no foreseeable problem. It's just a roll of the dice. A trust is a plan. You direct what happens if. The worst case scenarios are treated as carefully and thoughtfully as the best. Reason number two, they're contested. The biggest reason to avoid probate for a lawyer is not the cost, it's the uncertainty. And by the way, it's the uncertainties that so often makes probate so expensive. Anyone can contest a will, including the judge. If contested, most wills are invalidated. Why? The law simply does not trust them. The reason? History. From the 1600s in England to the American West, late 1800s, early 1900s, landowners used scriveners, the precursors to modern lawyers, to commit fraud by drafting wills for people so that they would inherit the land when they died. Over time, courts made contesting wills easier to protect families from third party abuse. These devices, TODs and PODs, are as easily contestable. One family member who doesn't like a particular result can legally burn down the will and all the transfer designations by going where? To probate. Worse, the contest may change the direction of your estate. A beneficiary may convince a court that a sibling, for example, aided in creating the devices for their benefit, even if only to prevent the challenging child from serving as executor. The court may reduce or eliminate the beneficiary's share in equity, a term that means fairness is determined by the judge, but often without regard to your wishes or intent. How many times have you heard that one person in a family received everything in a probate dispute? This is how it's done. Trusts, unlike wills and transfer designations, are generally incontestable and therefore a much more certain plan. Reason number three, they don't always work. These devices don't always work to avoid probate, to accomplish the only objective that they're intended to accomplish. By being easily contested, as I've just explained, they actually encourage probate. And in situations where guardianship is necessary because there is no plan, they actually result in probate. But there's more to the story of failure. How long does a beneficiary have to survive a death to be considered an eligible beneficiary? Did you know that was a thing? It's called vesting. With accounts, the rules are made up by the custodians, the bank, the insurance company, the stockbroker, whoever creates the account. With TOD deeds, the law defines vesting. Here's the rub, though. They don't always work the same. And more, most people don't understand the consequences. I've been into many banks and asked bankers, how does your transfer upon death designation work in terms of the time period by which the beneficiary has to survive the maker? And they don't know. A lot of these people just pass them out like candy, and they have no idea how they actually work. So let me give you some examples of why this can create problems. Let's say a son dies 29 days after mom for a bank account that requires 30-day survival. The account goes to a contingent beneficiary if she made one and they qualify. So in that situation, there would be no probate. If there is no contingent beneficiary, guess what? Probate. Or if the beneficiary doesn't qualify, probate. If he dies 31 days after, now he's a qualified beneficiary. We would have to probate the assets, though, in his estate. And the assets would pass according to his will and not according to mom's wishes. We still have probate. Every account may be different, leading to different results and encouraging different outcomes. What do you have when you have different outcomes and different results? Disputes and contests. And where are those resolved? Probate. Reason number four, they're challenging to manage. The typical person has 5 to 7 accounts: checking, savings, a money market account or CD, an IRA, an annuity, a life insurance policy, and possibly a brokerage account. If you're a couple, you may have close to double or more that number. Regardless of how many you have, if you want to change your estate plan in the future, you must do so each account that has a beneficiary designation or TOD or POD. That means 5 to 7 different forms at 3 or 4 different locations. You know what happens over time? You stop doing it. So your estate passes at your death to the wrong people. When you pass assets and property to the wrong people, or you pass it inconsistently from one asset to another, there's a fight. When you have a trust, you have one document. If you need to change it, you change it one time, and it changes the direction of everything you own. Now you will make changes and you will keep it current because it's easy and it's done in the comfort of your own home. Fifth, you risk your family home. Transfer on death deeds are all the rage. They're passed out by realtors and they're passed out by lawyers that do real estate and don't do estate planning like they're candy without regard to the consequences. Let me give you an example. In the days, weeks, or months after you pass, there's a storm or a fire and the house is damaged or even lost. Maybe vandals come in during the funeral and rip out all the copper pipe, doing over $100,000 of damage, an actual case in Cuyahoga County. Your family paid the insurance, so it's fine, right? The insurance company is going to reimburse the family. No, the insurance company denies the claim. The property transferred at death, and the insurance policy in your name no longer insured the right insured. Even if the beneficiary on the deed knew about the transfer on death deed and didn't transfer it, didn't go down and clear title, they are the owner, and the insurance no longer pays anyone for the loss. The best thing that happens is you sue the insurance company and you recover the premiums that you've paid for insurance that won't pay your family. You've lost the house because you had no plan, only an objective with no path to success. A trust solves all of these problems. More than anything, these devices stand as a testament to the fact that probate should be avoided as a costly, uncertain, and destructive thing to family harmony. But they should not be used in most well-planned estates and should not form the basis of any estate plan. These are 5 reasons, and they're good reasons. You probably aren't surprised that there are more. If you want to know more, go to my blog, the Aging in Place Planning and Elder Law blog. I've written more than 10 posts on direct transfer designations, many of which include real life cases, including the case in the state of Ohio that actually held that a family could not recover against an insurance policy that they paid for after death because of a transfer on death designation deed.